And in those pictures, there are thousands of screws on the buildings that are put on poorly.
The pictures you showed us had essentially you're using the term screw. Professionally, they're called fasteners. Am I correct?
It's interchangeable. Sure, we can go with fasteners if you'd like.
Okay. And so you say that the pictures that you didn't put out had multiple screws / fasteners that were not just one per picture, correct?
That's correct.
Is it fair to say you just showed one for each of those pictures that you did show to the court?
I don't recall every exact picture, but my testimony is that the fastener placement was horrific.
Okay.
Throughout the roofs.
Were all of those holes that were caulked over, were they all caulked over?
No.
You showed all the examples you showed were all caulked over, weren't they?
I believe most of them were, yes.
Okay. I know at Home Depot, you go and get caulk and it says 20 years or 10 years. But would you agree with me that really they don't last 10 or 20 years when they caulk something on the outside? Would you agree with me?
I would agree.
Okay. But at least they would keep the water out for the next rain, wouldn't they?
No.
You're saying if you caulked a nail hole or a screw hole, it wouldn't even hold for the next rain?
That's a bad bet to make.
Okay. But you're not here as an expert today, are you?
I've been in the roofing business for over 20 years.
You're not here as an expert, designated expert, are you?
I'm a plaintiff today.
Okay, and you're not here as a designated expert, correct?
I've not designated myself as an expert.
Okay. Now, why did you think that Mr. Cook would go get a policy of insurance for something? Well, first off, you're saying he's committed fraud, that he knew when he went down there to get insurance, he was getting one that did not cover the project that he was, his company was contracted to do. Is that your position?
We're suing him for fraud, yes.
Right, and fraud means he knew before, at the time he signed this agreement on behalf of CRC Residential, he knew that he wasn't going to get insurance. Is that what you're saying?
I'm telling you, it's my opinion, that there's no way he could have overlooked that.
Okay.
We had specific conversations on the requirements to roof this church and this private school. This was an ongoing conversation. There was no misconstrued
objection,
directives.
non-responsive. I'm not asking that.
We were very clear. We were very clear on what we needed from Mr. Cook.
Okay,
clear.
You say we. How many, prior to the signing of the agreement, how many conversations, one-on-one or just you and Mr. Cook, did you have with Mr. Cook?
With my company, my staff had
objection, non-responsive. I'm not asking that.
I don't know the exact number. I don't know the exact number.
Did you even have one conversation with Mr. Cook?
I don't remember having a specific conversation with him about this, but I know he had conversations with my staff.
And you weren't there, and these weren't memorialized the way you've said it, which is that you had specific requirements Is that correct?
We have standard operating procedures for subcontractors to work for my company.
Okay.
And we have gone to great lengths in our contract to specify the types of insurance, the types of coverage that are required to operate in this workspace. And all of
Objection,
those
not responsive.
requirements.
Sir, I am not asking you about your, I will in a minute, about your, what you're bringing up about certain standard operating procedures. You're saying those are in the subcontract agreement, your standard operating procedures?
The insurance requirements are.
Okay. And those are the ones that I showed in opening. Are there any others that are written to Mr. Cook?
We provided him with the subcontractor agreement.
Right. And in 6A of that, that was the one that I showed in the in my opening statement, correct?
I
It
don't
says
remember.
commercial general liability.
I don't remember your opening statement.
Okay, it's just a couple of hours ago. Okay, in it, we pulled up a your exhibit 1, and we pulled up page 3. It says subcontractor insurance requirements, and under it had A is commercial, B is business auto, and C is workers' compensation. And the one we're here about today is A, the commercial general liability. Do you disagree with that?
What part of it?
Okay, we're not here on any, you're not complaining about his business automobile insurance not being adequate, are you? Are we?
No.
Okay,
No.
or about a workers' comp. We're not here on that. Okay, old, okay, so aren't we here on 6A, the commercial general liability insurance requirement?
While we're here.
Huh?
That's why we're here. Yes.
Right, and that lists what these standard operating procedures are without using that term, correct?
That's correct.
It's got the amounts of the policy, and so why would Mark Cook go get an insurance policy that didn't cover this because it had an exclusion for a house of worship and for a school? Why would he go get this policy if it didn't cover it? I mean, why would he pay the premium on something that didn't have coverage if he was trying to be fraudulent, if he was trying to lie to you?
Objection, calls for speculation.
Sustained.
Okay. Okay. Judge, by that I can assume that they don't know the answer to that. You don't know the answer to that, correct?
Objection, Judge.
You'd be
Ask the
speculating?
same question, just another way. Calls for speculation.
Sustained.
Okay. Now,
Do you have anything else, Mr. Clark?
okay, yes. On Mr. Cook, is it fair to say that y'all talked and you said there was no way to repair it, only to replace the entire roof, correct?
Correct.
So you're saying there were no panels that didn't have misshot holes. Is that what you're saying? Is that what you're saying?
Yes, sir. Yes, sir.
And you're saying none of the panels could have been redone?
That's correct.
And if one was misshot, that would, let me ask you this, do these overlap, these panels?
They do.
Okay, so you could get one that was misshot and overlap it with another one, couldn't you?
Way too many messed up fasteners up there, sir. Way too many.
Okay.
Way too many. Church was not going to accept anything but new metal.
when did you, when you met Mr. Cook, did you accuse him of fraud when you met with him personally?
No,
Did you say that he did anything, made any mistakes on purpose?
no,
Okay, until you got lawyered up, you didn't come up with this fraud allegation, did you?
when I found out that his insurance policy did not meet my requirements, I can only speculate that he bought a cheap policy
Well,
to meet my
objection,
requirements.
they're objecting to speculation, but they wouldn't let me ask.
Sustained.
So you saw this this insurance policy after the lawsuit was filed, correct?
Yes, sir.
Okay, and you got a deck sheet prior to that, I guess at some point after March, but before the project was finished, correct?
Yes, sir.
Okay, and did you find anything on that deck sheet that was fraudulent or inaccurate?
Now, the deck sheet, you have to show me the deck sheet because
Well, y'all didn't put it, y'all have alluded to it. So you sitting here today, do you know anything inaccurate on the deck sheet?
in terms of the coverage amounts,
Yeah.
I don't believe so, no.
Or on as far as anything on the deck sheet?
I don't believe there's anything on the deck sheet that's fraudulent.
Mr. Clark, I'm gonna need to take.
Okay, I'm gonna pass
break.
the witness.
Okay, good, perfect. Let me do this. I need to take a quick break. First off, I do have a serious concern about the disclosures by the plaintiffs in terms of the not calculating damages. And so there was a trial brief submitted by Mr. Clark.
I can address that right now.
Okay. Go ahead.
First of all, Judge, all of our evidence, all of our damages are in evidence. All of those damages have now been tried by consent without objection. They are exhibits in the court. As it relates to the disclosures, the evidence regarding the damages, like I said, have been tried before, but Rule 193.6 clearly states if the court's of some opinion that we didn't properly supplement, which I respectfully disagree with, simply says that he has to show prejudice or surprise. He simply cannot do that in this case, and this is why.
Okay, so let me just ask this: the version that he showed me in terms of it's $100,000, but with no calculation, is that what the final disclosures were?
It was the methodology. What his case, the one case that he has that has something to do with it, talks about methodology. That some methodology was changed, and that's the county case that he cites in his brief, which has to do with change. We never changed our methodology. It was what it cost us to replace the roof.
Okay,
It
all
has
right.
never changed.
So, sir, let me just finish what I was saying, okay? This is the situation here. There is case law that I've seen before about it's not clear cut what happens in this situation. Clearly, there's an issue because there was no calculation of damages. Whether or not the proper remedy is to strike all damages or to do something else. Mr. Clark has submitted a brief that indicates that seems to indicate that we should strike all the damages. Did you ever file a counter brief to that, or did you submit any type of briefing, or do you have any type of?
Because I thought it was the most ridiculous thing I'd ever seen.
Well, I don't.
I have all the evidence right here that the court needs with regard to that.
And Judge, I filed my brief and my objection May 17th. So it was way before the trial.
All that's necessary to show, Judge, is that there is no prejudice or surprise.
Give me some case law that says that you don't have to provide any type of calculation of damages.
No, that's not what it says. It says that failing to timely respond or supplement. It says that if there is an excuse.
I can't hear you.
I'm sorry. I turned away. Let me put this right here. 193.6, the Texas Rules of Civil Procedure, clearly says unless the court finds the following, it's the exclusion of evidence, that there was good cause for the failure of the party to timely make, amend, or supplement discovery response, or 2, that the failure to timely make, amend, or supplement the discovery response will not unfairly surprise or unfairly prejudice the parties. Okay, Mr. Cook's website claims that he's an expert in roofing, and he fixes other roofers' mistakes. This is what the evidence has to show for the response. Plaintiff's Exhibit 5 was an email that was sent to the defendant on 1/22/20, which is in evidence, that lays out the cost of the materials and the cost of the different elements that it would take to re-roof the church and the school. Plaintiff's Exhibit 9, which is a summary of the damages, actually reduces the $100,000 to less than half.
Mr. Cross, let me just read this out of O'Connor's. If you have the most recent O'Connor's, this is what it says about damages and failure to disclose damages under your request for disclosures. A party must disclose the amount of economic damages and any method of calculating them pursuant to Texas Rule Civil Procedure 194.2D. For example, plaintiff must be required to show how loss of past earning and future economic earning capacity was calculated, and a defendant in the same suit would be required to disclose any grounds for contesting the damage calculations. Texas Rule Civil Procedure 194, comment 2. If a plaintiff cannot demonstrate its method of calculation, the court may limit the damages the plaintiff can recover. See Bhutan, B-U-T-A-N, Valley, N-V, N-V, versus Smith, 921 Southwest 2nd, 822, 832. A party is not required to state a method of calculating non-economic damages, such as mental anguish. It's the issue here is the failure to provide a calculation of damages in the disclosures. And so you might feel this is ridiculous, Mr. Cross, but I have to follow the rules of civil procedure.
Judge, you are fine.
Please don't interrupt me again, please. I'm trying to give you a chance here, Mr. Cross, to provide some counter briefing to this. If you don't want to provide any counter briefing.
I'm happy to, Judge.
Okay. So let's do this. Do you want to do that? Do you want to finish this trial? Because I think it's kind of pointless if I follow what's in O'Connor's, which I tend to do. We're trying this for nothing because all the economic damages would be struck. I do agree with you that there's situations where you may be able to get around that. I just want to see case law that says that. And so my suggestion would be, if everyone can do this, that we reconvene this trial at some point in the future to give you an opportunity to do that briefing. But we don't have to do that. We can do this some other way, but I am seriously concerned about this particular issue, the failure to calculate. This isn't the first time this has come up. I've seen this issue a number of times, and there's a number of cases on this issue. Mr. Clark cited 4 or 5 in his brief. I just haven't seen any counter briefing. And so how do you want to, Mr. Clark?
I'm happy to provide you with cases that clearly show that, number one, all these issues have now been tried by consent without objection. All the evidence is in evidence without objection. They were admitted by the court. Number 2, 193.6, there are 2 cases that I'm looking for them right now, and I can't find them on my desk. They clearly talk about what I have to do to show you that they're not surprised by this, the kind of facts. And one of the cases that I had says that it was on attorney's fees. It says that they hadn't properly, timely supplemented something, or they supplemented it late or something. They were requesting attorney's fees. And the court found that was good enough because from the day one, their petition claimed attorney's fees. And that was not unusual. There's some other case law that talks about, I think, and I can't remember the specific case. It may be this Dallas Court of Appeals case that I have back here, but I don't have it highlighted, so I can't.
Mr. Cross, I'm just trying to figure out a timeline here right now. If you want a chance to brief it, you can. I would highly recommend that if I were you, but you don't have to.
I'm happy to brief it, Judge. I already admitted that. I already said that.
Okay, so let's talk about Mr. Clark. What would be your thoughts on how to proceed? I know it's, I wish he had done a brief before this because I think I think this is a serious issue, but, do you want to try to finish this trial today, or do you want to put this off and give him a chance to brief it? I'm not going to rule on it today because I want to give him a chance to brief this, but do you want to finish the trial now, give him a chance to brief it, or do you want to reconvene some other time?
Well, let's see, I'm not through with but I think I have passed, I believe, Chad.
Yeah,
And
you did.
they want to call Mark, and then we've got some attorney's fees issue. Tell you what, I've known Kerry a long time. I'll let him make the call, but not just, I know he doesn't want to do either. But I think he should be A or B. It's multiple choice. He either proceeds, and he may want to have it both ways. He may want to proceed with the trial and have time to brief.
That's fine. Do you want to finish the trial now, or do you want to come back and finish it later?
Well,
Understanding that you're going to have a chance to brief it.
I think it would be prudent to brief it first, Judge. I think it'll be clear to you at that point.
How much time would it take you to brief
I can
this?
have it to you by Friday.
You want to finish the trial Friday afternoon then?
That'd be fine.
Mr. Clark?
Friday after, I would need a few hours to look at his brief. I may want to do a reply, Judge.
How about what if he got you the brief by Thursday at noon, and then you give me my brief Friday at noon, Mr. Clark, and then we do the trial Friday afternoon?
Judge, I'm having a minor medical procedure on Thursday morning. It's I guess where they go down your throat or something.
Okay. Do you want to do this? Do you want to turn the briefing in and we could finish the trial on Tuesday?
That would be better for me.
Mr. Cross?
That's fine.
So you need to get your briefing in by Friday. Mr. Clark, you need to get your briefing in by Monday, and then we'll finish the trial next Tuesday.
Can I look at my calendar real briefly?
Sure. Mr. Clark, how do you look next Tuesday?
Well, okay, looks like I've got a couple in the morning, but we don't know if we're called. Let's see. So would this be in the afternoon of the 15th?
It's up to y'all.
Yeah, in the morning I've got.
Why don't we just start at 9, and then if we have to delay it to the afternoon because of your schedule, Mr. Clark, or my schedule, we can do that. But why don't you report in at 9 next Tuesday?
I will. I don't know if I'll be called. I've got one in the 162nd and one in the 298th. And then I've got a hearing entry of a judgment at 10 a.m. that morning, but nothing in the afternoon.
All right, so we're going to delay this trial to next Tuesday. Mr. Ward, I think you're here, and your opposing counsel, Ms. Schober, is here. Have you guys been able to settle this case?
No, Your Honor, but I believe we're ready to go.
All right, we're going to start the trial in 10 minutes. We'll be back in 10 minutes.